Good afternoon, Judge Phatudi.
Good afternoon, Chief Justice.
How are you, sir?
I am together, and yourself, Chief Justice.
I'm very well, thank you.
Yes. It's like,
yes.
no, I was just saying I'm well, but coming here, as you know, is like
It's not easy.
It's like walking the 52 steps towards Calvary.
Okay. No.
It's not that easy. It's not
You are a very strategic man. You are a very strategic man. Anyway, Judge, tell us how many years has it been now on the High Court bench?
In July of this year, it will be exactly 5 years as a judge.
And have you had the opportunity to play some leadership role, whether at a committee level or at any level, whilst a judge of the High Court?
Yes, indeed, Chief Justice. I have, for 2 terms in succession, the beginning of February 2019 to the last day of June of that year, I've been acting as a Deputy Judge President, Limpopo Division.
And tell us how, as a judge and as acting Deputy Judge President, you were able to equip yourself for this position that you're applying for, how that opportunity enabled you to identify the challenges, reflect on the solutions, and actually identify possible solutions to the challenges that confront the division.
Yes. Whilst acting as either a judge or acting judge president, I had occasion to interact with the magistracy in almost all districts, ranging from Musina to Bilabila, Palabora in the east, and Lepalale on the west, including from Polokwane downwards to Bilabila. The challenges that I've experienced are mainly infrastructural in nature, in that most of these, the courts, the district courts, actually have dilapidated infrastructure because they are old courts which were established way back during the homeland system. And some of them were built by the previous regime prior to the establishment of national states authorities, that is the homelands. Now, they are old. Some of them have leaking pipes, and electricity most of the time fails because of the old cables, which are more often than not destroyed by mice. I know for a fact that a court in the local division of the High Court in Tohayando, for example, was gutted by fire, occasioned by failing old cables, electricity cables. Not only that, actually most of the problems around Limpopo are almost similar. I have done research myself with the regional court president, who was kind enough to provide me with a list of challenges, and which I have also confirmed when I visited certain of those affected magisterial courts. And the Chief Justice wants to know what's the solution. I think this requires political intervention. The
political or executive? Political or executive?
Let's call it executive to be precise, and I stand corrected. The the Department of Public Works, which is well known to be an executing agent or department of all state departments, is required to make sure that there are maintenance contracts in place. Because the problems are the same, shortage of water, especially in the area of the in Toyando area. And it's not even a question of whether ESCOM has cut lights or is load shedding, but the municipalities in some cases simply don't pay the required bills, and the costs are affected. Another thing, another challenge that I've picked up, Chief Justice and the Honorable Commissioners, is that there is a competition rather between the Department of Public Works, that is the national one, vis-a-vis the Department of Justice, in the sense that one would pass the buck and say, but it is that building, for example, the Polokwane building, which was gutted by fire some 5-6 years ago.
The magistrate court.
That is indeed, Chief Justice.
Yes.
There has been a tug of war between the two departments, as if there's no cooperative governance established under Section 1441 of the Constitution. That department, there must be interdepartmental cooperation, but that hardly occurs. Like in this instance that I've just mentioned, there has been a challenge as to which department is responsible for the maintenance or refurbishment of that court.
Yes. All right. Now, just to step out of it, you know, on the occasion of the official opening of the Limpopo High Court,
yes,
the JP, Minister Masuta, and I, the regional head, and I stand to be corrected, but I think even Public Works officials had an urgent meeting there, and all those challenges were identified, including the Limpopo Magistrates Court. Yes. And we were led to believe that, you know, it's just a matter of a year or two, everything would be resolved, including the water that tends to flow quite ferociously on the basement of the newly built High Court itself. So are you saying that that hasn't been resolved yet?
No, not at all.
The infrastructural challenges that had been there throughout the province, as well as the High Court itself? No,
that has not been done, Chief Justice. And I have before me, for example, a report dating as early as 2019 in June.
Yes.
Which I've sourced from the office of the regional court president.
Okay.
And
all right. No, that's okay. No, I think it is okay on infrastructure. Yeah. Apart from infrastructural challenges, what other solutions have you identified as those that you could share with the JP to strengthen the leadership of the judiciary in the province? Just very briefly.
Yes. One other area of concern that was raised by some of the regional court magistrates was that they've got a problem with lack of office space.
Sure, yeah.
And secondly, the legal aid practitioners are few and operate in, for example, in Zanin, regional court, we only have 2 legal practitioners there, drawn from the legal aid South Africa. And there's a lot of work, according to the report that I see here, of which now the 2 cannot cope. And the issue of the fastnet internet, for example, so yes, as to enable virtual appearance is also a matter of concern.
Yes. Now, but what strengths are you bringing in very quickly as an individual? What is it you know? What skills, what capabilities have you developed that you are going to inject into the leadership of the judiciary in the province? Just very briefly, additional to what you have already told us.
Chief Justice, it is very important to keep a rapport from time to time with the magistracy, so that you are able to, one is able to diagnose what their problems are. Not only in relation to failing infrastructure, but also in relation of other administrative of matters. One other quick one that I mentioned quickly is that the acting magistrates, for example, who have been appointed are allegedly lacking in terms of experience and training. Therefore, it would be adequate for one to introduce the same training course that is offered to the regional court magistrates to be extended to the acting magistrates. And SAJ would be an appropriate body to educate.
Well, for what it is worth, you're going to have a big fight with the Deputy Minister of Justice and Constitutional Development. He serves in the SAJ Council and he has views on extending training to active magistrates. But that's an argument that you can have with him on the side. Let me hand over to Judge President Makobase, and then the more that you need to say will come out as commissioners I put questions to you. But before I do, may I have the names of my colleagues who want to put questions to Judge Phatudi, please?
Lamola.
Muimang.
Tepe.
Matolo Lepu.
Mpofu.
Malema.
Jenny Kane.
Bonard.
JP Mlambo.
All right. Thank you very much. JP, over to you.
CJ. Thank you, Chief Justice. I don't have any question for the candidate. Thank you.
Thank you very much, JP. Mr. Singh?
Thank you, CJ. Good afternoon, Judge Phatudi.
Good afternoon, Commissioner Singh.
So whenever traditional leaders litigate against the provincial government, they always cite the Premier and the MEC, obviously because the assignment of the traditional leadership legislation is assigned to the MEC Coxstar.
Yes.
Recently, we were at the High Court, and luckily for us, the JP dealt with the matter, where the litigants asked for the Premier to be held in contempt because they hadn't complied with a court order where they were given 10 days to recognize a senior traditional leader. If you are appointed to this post, how would you ensure that we don't have unreasonable court orders like the kind I'm explaining about?
Well, the question of non-compliance with court orders is a matter of grave concern to the judiciary and under general. The quickest way to do it is to undertake what I would call a mediation process. You call the parties in default and sensitize the official whether about the non-compliance with the court order and show the consequences that might ensue for want of compliance. Unlike to flex one's muscle and immediately issue out a warrant or authorize a warrant for the arrest of the Premier or MEC. But if it comes to a push, after being sensitized in that way and nothing happens to us complying with the court order, then there's no alternative because the law says judges are there to uphold the rule of law without fear, favor, or prejudice.
Thank you. Just a quick follow-up, CJ. No, I understand that, and thank you for that answer, Judge Phatudi. But I'm talking about cases where the court order issued by the judges themselves is unreasonable. As you would know, it is highly unlikely to recognize a senior judicial leader within 10 days, given the processes that was followed before recognition.
What is the question?
So the question is, how would you, if appointed to the position, ensure that the court orders made by some of the judges are not unreasonable to the extent of the one I'm talking about?
Well, as I've indicated, unless I don't understand your question, I would say upon reading a judgment, of which now has a court order, and there is a period within which there has to be compliance, you need to give grace. For example, call upon the defaulting party that you are required to comply within a certain period of time. And if you do not, then it means you are visibly in contempt of court.
Thank you, CJ.
Just a follow-up, CJ. I know I'm on the list.
Thank you, Honorable Malema. Go ahead.
Judge, is it possible for you to tell another judge not to issue unreasonable judgment?
No, that is not possible.
It's not possible.
It's
Thank you.
actually, you would be trying to review or appeal judgment of a colleague, which is not acceptable.
So it is given that from time to time there may be unreasonable judgment or reasonable judgment,
Yes.
which you have no control over as a DJP.
Indeed, yes.
Thank you.
And the avenue is clear for one to approach the higher courts for relief.
Honorable Moganishe. Thank you, sir. Thank you.
Thank you very much, CJ. Good afternoon, Judge Phatudi.
Good afternoon, Commissioner.
I would just like to raise a few issues which were raised as comments against you,
Yes.
and give you an opportunity to respond to those comments. One, it is said that you are very disrespectful to practitioners who appear before you. You presided on a matter involving your wife, and that judgment was overturned. And if you can just update us, how far is the dispute between yourself and the Society of Advocates regarding the property deal? If you can just comment on those issues.
Thank you, Commissioner. I had expected this question to arise, and I've prepared a 37-pager document. I'm not sure whether the Honorable Commissioner has received that document. To answer your question pertinently, there is no dispute between myself as a judge and Polokwane Bar Association. It is only a comment raised on behalf of that association by the author of that letter of objection. The property was indeed let out to Polokwane Society of Advocates at the instance of its chairperson. I'm not sure whether you want me to provide the name because it's there in the documents, but he approached me on the day on which the Polokwane court was open, and he said to me, Judge, we have got a serious shortage of office space for the newly admitted advocates, or rather pupils who had just passed pupillage. Then after the official ceremony, opening up of the court, we drove together to my former office where I practice as an attorney. He inspected the premises and immediately asked that a lease be drawn rather, and agreement be entered into between Polokwane Society of Advocates and MG Phatudi Incorporated, which is the owners of the property, not the legal practice or legal firm rather. From there, a lease was concluded for a period which had a period of 5 years duration. And in the second or so years, notice was given that they are pulling out because they can't pay rent to MG Phatudi Incorporated, which is an independent juristic person. And from there, later I was notified that the company, that is the incorporated company, may sell that property to any other interested buyer, willing buyer or seller, between willing buyer and willing seller, I want to say. Then from there, the property indeed was purchased, and the new owners wanted to continue to receive their rental. That is where the dispute began. And that company, the new owners, apparently issued summons against Polokwane Society of Advocates based on the lease agreement. Now, for that reason, I am personally not having any dispute with other members of the bar of Polokwane. I know I've been interacting with them throughout from 2016 upon my appointment as a judge to date. And if you look at the document, Commissioner, you'll note that this is a repeat of old and stale allegations, amongst others that I've presided over a case in which my wife was a party. That is not correct. I think they've dealt with that issue on page 5. Okay, maybe let me put it paragraph 17. I know I've paginated my documents. And I've dealt with that matter in the sense that the applicant in the matter consent was one in which Silver Edge Training was the applicant, and the MEC for Education Limpopo was the respondent. The matter revolved around a review of a tender which was disputed by Silver Edge, pursuant to a certain report emanating from, and I know I might bend my fingers here, from Minister of Finance at the time, because there was a lot of corruption in this tender. Phatudi was not a member of this close corporation, nor holds any interest therein. Additionally, she was not party to the litigation as alleged at all. And I've actually provided the honorable commissioners with a CIPRO, that is Certificate of Intellectual Properties, the one issued by the Register of Companies. And to my recollection for that matter, Commissioner, even the senior counsel who appeared in that matter, I don't want to mention his name, for the MEC, did not even bring a recusal application if he thought that I was conflicted. If I was, I would have simply recused myself. I know what conflict of interest is. So therefore, I want to submit that allegation that my wife participated has no basis. Actually, that report issued by the Treasury, if the Honorable Commissioner has gone through it, no mention of the names of the companies that participated in that tender appear at page 5 of that report. Nowhere is Mrs. Phathudi's name rather mentioned, but instead, the affected party there was Silver Edge, and Phatudi is not or was never been a member or holding any interest in that close cooperation business. So therefore, this allegation has no merit, and the evidence is there.
CJ, but please just follow up on Judge Phatudi. It's just a follow up.
Yes.
Let me first find out if Honorable Magwanisha has finished. Honorable Magwanisha, are you done?
The last part, CJ, was not answered. The last part is to the effect that they say that the judge is disrespectful to practitioners that appear before him.
Okay.
Judge Phatudi, it's important for us to ask you these questions. We have read the documents, but there are many people who are listening or who are watching these proceedings who have no access to the documents that we have.
I agree.
So it's
yes.
important that we do ask these questions.
Yeah. Let me respond. I beg my apology for having skipped it. It was not deliberate. I deny that I'm in any way disrespectful to any of legal practitioners within that organization. And remember that, as I said, Polokwane, if the members of Polokwane, if they had any gripe against me, I am sure by now, on the 5th year as a judge, the SGA would have received so many complaints of unethical, inappropriate, dishonorable, disrespectful, complaints within the meaning of Section 14 of the JSC Judicial Service Commissions Act. So far, nothing has been reported. I therefore, in a nutshell, want to make it very clear that I work very well with the rest of the members of Polokwane Society of Advocates. And remember, that is it's not the only bar there. We have another bar called the National Bar Council of South Africa, which has a lot of membership of advocates who never even raised a complaint alleged by the author of this damning objection. Secondly, we have Polokwane Attorneys Association. Many attorneys practicing in Polokwane. Not even one had ever raised a voice in which my conduct was deprecated as alleged or at all. Thirdly, we have another splinter group of some of the members, previous members of the Polokwane bar, who had formed a new bar called the G20 group. Equally so, none of them had raised any issue. So I therefore, in a nutshell, Commissioner, say that I've had a cordial relationship with the rest of the members of Polokwane Society of Advocates, except for this.
Thank you, CJ. Thank you, Judge Phatudi.
Thank you, Honorable Magwanisha. Commissioner
Sorry,
Matata
CJ,
Lepu,
there's
Commissioner,
there's something that arises out of that. It's just a short question. May I take it up at this point, please? Jenny came here.
yeah, can you come after the follow-up question by Commissioner Matelo Lepu,
And
please?
Cyril
Certainly.
the follow-up Chief
Thank you.
Justice, I will then forego my slot.
Okay,
So I had these guys, President Ramaphosa, these guys. Yeah.
Commissioner Matelo Lepu, I think one of the commissioners was busy with something else.
Oh, okay. Thank you, CJ, and good afternoon, Judge. I just want clarity. The issue of MJ Phatudi Incorporated, knowing according to our rules, and Incorporated is owned by attorneys.
Okay, no, not necessarily. I'll explain as follows. May I reply?
Yeah, that's why I wanted.
Yes, I would like to clarify that.
Yeah.
These incorporated structures are incorporated in terms of the Companies Act, and this one in particular is a personal liability company. It's just like a private company. Now, it doesn't always follow or necessarily follow that once you incorporate it, therefore it means you should be in legal practice. Incorporated companies are business entities incorporated under the company laws of the Republic. And it all depends the purpose for which it has been floated. The incorporated company may trade in tendering, road construction, or all other business opportunities that are there in the commercial, in normal commercial course. Then for even medical doctors, some had registered incorporated companies, but they're not necessarily attorneys. You have also pharmaceutical companies, the owners thereof, they register an incorporated company as a personal liability company, which exists separately from its members. So in my case, I was a single practitioner. The company was registered as early as the year 2000. In 2005, using the name incorporated, MG Phatudi Incorporated, then I managed to secure money to buy the property, not to buy the practice, because I was issued with a fidelity, MG Phatudi, in my personal capacity, was issued with a fidelity fund certificate, not in the name of MG, because MG Phatudi Incorporated is not an attorney to all intents and purposes. So therefore, there is this, like the writer of this objection, with respect, did not actually misconstrued how these entities operate. The moment I ceased to practice as an attorney, then I informed the Law Society that MG Phatudi Incorporated practice number 19190. I've ceased to actively practice and I am now going to join the judiciary. But the incorporated part of it, which is the owner of the building, remains intact. In other words, from now, anybody who's a shareholder in that or a director may enter into construction or mining or any other business entity.
No, sorry, Chief Justice. I just want, my problem is when you deal with such things, when you are an attorney and ceasing to be an attorney, it actually clouds issues. When you registered this Inc. before, who were the shareholders and who were the directors before leaving?
I was alone, single practitioner.
Then you dissolved, you deregistered the Inc.
No. I haven't deregistered it. I've relinquished my shares in the ownership of the building itself, of the company itself, with the result that anybody in whose favor those shares were transferred can now step into my shoes, but not necessarily as an attorney, because MG, that is myself personally, had ceased to practice as an attorney. And my name, I'm sure, wherever it is, it has been and put on the list of non-practicing attorneys.
Okay, I don't want to enter into a dialogue, but
No, I do want to have a follow-up on that issue. Chief Justice.
She's still on the floor.
Oh,
Wait a minute, Commissioner Matolo Dlepu, are you done with your follow-up?
not because I still have another opportunity. So let me give Commissioner Madonsela to follow up.
No, it's not even him. It's first Commissioner Kane. I just forgot who comes after Commissioner Kane.
It's Taba, who then forgo is not here.
Yes. It's and then Commissioner Madonsela thereafter. Okay, it's all follow-up. Nah.
Yes.
Okay. Yes,
Thank you,
Advocate Kane. Advocate
Thank
Kane,
you.
is your turn.
Thank you, CJ. Good afternoon, Judge. My follow-up question on this, you refer to William Macari SC complaint as being a single advocate, but he writes very squarely as the chairperson of the Polokwane Society of Advocates. And so your dismissal of the matter as if it's not on behalf of a broad body of advocates I'm putting to you is perhaps a little misleading. You perhaps need to explain or be fair that this is a complaint directed relating to from the chairperson of the Society of Advocates that practices in that division.
So I missed some of your words. And
I am sorry.
You'll pardon me if I don't correctly answer your questions. But the little bit I got was this: whether is this complaint not raised by Polokwane Society of Advocates. Yes, I've indicated that the chairman of that association is the one who wrote on behalf of the Polokwane. But the issues raised therein, which do not even rank within the definition of a complaint in the judicial sense, are, in my view, issues that emanated from him on behalf when he sought to let the property for purpose of use by the advocates who are practicing in that within that bar association. So I still want to. My thinking is that this is not a judicial complaint. If it were, I'm sure the Judicial Service Commission would have received a complaint within the meaning of Section 14.
CJ.
No, let me just try and see if we can narrow the issues here.
Yes.
Judge, who was in charge of this Phatudi Incorporated ever since you became a judge?
The property, the shares, let me say, of MG Phatudi Incorporated were transferred into the name of Me Phatudi.
Now, was Me Phatudi the warm body behind Phatudi Incorporated? Was she the one running this property that belonged to MG Phatudi Incorporated?
Yes, after my departure from as a legal practitioner. So in other words,
yes, but you are the one who drove the advocate to the building.
yes, I facilitated. If you look at my response, Chief Justice, I said I facilitated.
No. I'm just trying to narrow the point.
Oh,
so
yes.
you took the advocate to the building,
Yes.
and I take it, showed him around.
Say it again, Chief Justice.
And showed him around.
Oh, yes.
Showed him.
He inspected the building, yes.
And then did you conclude the agreement with him, or did you leave it to your wife to then conclude the agreement?
I left it to Me Phatudi, who signed the lease agreement, because I was a mere facilitator.
Okay.
I think on page of this response,
So you, as a judge, you were facilitating this contract?
I facilitated the use of the building. The lease was signed by Mrs. Phatudi.
Okay, all right.
Yes.
Now, thank you. Honorable Kaba?
Thank you very much, CJ. I would have wanted to follow up on the question that the CJ has asked.
Yes.
Whether the shares that were transferred that are now registered in the name of Me Phatudi,
yes,
constitute a declarable interest in terms of the disclosure of interest policy of judges.
Yes.
And if yes, were these interest or this interest declared accordingly? Then my second question, Chief Justice, because it's unrelated to this one, it's a follow-up on Mr. Commissioner Makonisha's question. To the extent that the judgment in question was overturned, was this allegation of conflict of interest one of the issues or matters raised in the review or appeal application? Thank you so much.
Okay.
Thank you, Chief Justice.
All right. Commissioner Kaba, the position is as follows. In relation to your first question, if you have regard to paragraph 5, starting from paragraph 7, I'm not sure whether you have a copy, but I'll read it into the record for your purpose. And it reads as follows for those who found it. Significantly, this transaction was still was until the property was sold to Tshwaranang and registered its name as new owners on 26 November 2018, disclosed to the registrar of judges' registrable interest as a source of other non-judicial income that accrued to MG Phatudi Incorporated. And I've repeated this on paragraph 9, same page, that this transaction was, as already indicated in paragraph 7, disclosed to the registrar of the judge's registrable interest at the time. There was nothing, therefore, unlawful in that transaction, as the writer alleged there. That is the first part of your question. The second one is whether, as a result of this alleged participation of Phatudi in this review, clearly, as I already indicated, the writer of the objection had misconstrued the whole thing, in that Phatudi never participated in the tender, in the dispute, and secondly, she holds no interest in the work. But what has happened is this: when the matter was before me, argued between the MEC, who was the respondent, and Silver Edge, the document which I have referred to as the report on the verification of compliance with Treasury, norms and standards, appointment of 9 manufacturers. I'm not sure whether you've seen that, Commissioner Trevor. It gives a detailed background of what led Silver Edge to approach the court by way of review. Because according to him in his papers, the officials were handling that tender were somewhat, according to him, corrupt or were corrupted. And the report is quite detailed. If you have a look towards the end.
I think, Judge, you have answered me that this matter in particular, this allegation of conflict of interest, never featured before you, and it never featured even on appeal or review.
That's it. And if I may add quickly, if this very report was made available before the court, either by the applicant or the respondent, surely that SCA decision would have turned otherwise, because it was not made available.
CJ.
If it's a follow-up, Commissioner Malema,
Yes, follow-up on that incorporate thing.
Yes, is that before? Let's come with Commissioner Madonsela, and then you'll come in.
Okay.
Thank you.
Thank you, Chief Justice. I'm also dealing with this incorporated thing. If a company with limited liability owns a property in which you are a shareholder and a director, sole shareholder and director. Judge Solomon, good afternoon, Judge.
That is right.
How do you relinquish ownership of the property?
By transfer and registration in the office of the registrar.
Transfer of what?
Of the property itself, not the shares,
so,
in the incorporated company.
So you transfer property to who?
To the new owners. In this case, is Tshwaranang.
So you transfer the property from the incorporated company.
Ownership of the property.
But the company
owns the shares and the building itself.
How do you then transfer ownership?
Of the property or of the shares?
Of the property.
No, as I say, upon deed of sale of an immovable property being concluded.
Between who and who?
between the owner, the registered owner in the deeds office. Then it was myself in my personal capacity, not as a judge. Because when I got this property in 2005, I was not yet a judge. So the property was registered as under MG Phatudi Incorporated, of which I was the sole owner.
So you're not owning the property personally. You're
No,
owning.
yes, which is why I was able to, the property was sold as an incorporated company.
No, 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 no. You said you owned the property in your personal name. Then you turned around and said you owned it in the company's name. Which is which?
I'll repeat, unless I miss something, but I say in the year 2000, a company, MG Phatudi, was incorporated. And whilst it was in business or trading, in 2005, in the same name of MG Phatudi Incorporated, then purchased the building and continued to trade as a legal practice, whilst I am an attorney. And when I relinquished my status as an attorney, the property still retained its ownership of incorporated. That's how it is. Now, if somebody were to trade, as I say, outside legal practice, let's say before it was acquired. Let me give you an example that after having transferred the shares in the incorporated company into Phatudi, then she would have easily, for example, traded in any other field except legal practice because she was not an attorney. That's how it is. And then upon sale of that property to Tshwarana, cancellation, those who understand conveyancing would say that there is transfer and registration that has to take place in the deeds office. And that's what took place. No any person could have effected transfer because from the word go, the property was under MG Phatudi Incorporated.
I'll go back to the question I asked. So how then did you relinquish ownership of the property when the property was held in the name of the incorporated company?
We don't relinquish ownership. You transfer ownership by registration in the deeds office.
I'm using your words. You said relinquish.
No, I mean the shares.
Yeah, relinquish the shares.
Not the property. Mr. Madonzela?
Justice, I'm constrained because my learned friend, Commissioner Limpopo is offering questions loudly behind me, and I don't think it's proper.
Offering questions.
I'm leaving it at this because I wanted clarification for myself.
Chief Justice, I apologize. I didn't even see that my mic was on, and I realized now. Sorry, I'm sorry, Chief Justice.
It's not the problem about the mic, about you offering answers from the side. That's a problem. Let me leave it at that, Chief Justice. I think we have traversed the matter.
Yes.
Thank you. Thank you very much, JSC. Honorable Malema.
Thank you, CJ. I'm going to try and engage with this thing from a layman's perspective so that we avoid this lawyer's approach on this thing. So now, in 2000, you established a company called, you're calling it Incorporate.
MG Phatudi Incorporated. Yes.
It's a company.
Yes, it's a private company.
Registered with CIPRO.
Yeah. In the deeds office.
No, not the house. Let's leave the house.
Yes.
You register a company with CIPRO.
That's correct, yes.
And then it's called MJ Phatudi Incorporated.
That's correct. Yeah.
You are a director.
Yes.
And then you are 100% shareholder of that company.
That is correct.
Alone.
That's correct.
In 2005, this company where you are a director and a 100% shareholder buys a property.
Yes.
While you are still practicing as an attorney.
That's correct, Commissioner.
Then you get appointed as a judge.
Yes,
You then relinquish the legal practicing as an attorney.
that's correct. Yes.
But the company continues to live a life of its own
That's right.
with you as a director and a shareholder.
That's
Director and then when you now getting out
yes.
as an attorney,
Yes.
but because the attorney is not the company,
Yes.
the company as a legal persona remains with CIPRO,
That's right.
registered with CIPRO, but it's called Phatudi Incorporate.
That's right.
You remain a director
Yes.
and then you become a judge.
Yes. But before I became a judge,
Yes.
I then relinquished the interest in the company.
I'm still coming there.
Oh,
I'm
yes.
still coming there.
Okay.
So you now become a judge because
Yes,
there are two things here: is directorship and shares.
Yes.
And we shouldn't have confusion about the two. You can be a director and not be a shareholder.
That's right.
You can be a shareholder and not be a director.
That's correct.
Now, I want to understand when you become a judge, what is the first thing you release? Is the shares.
Yes.
You then took the shares to Tswarana,
No. Before that, to Phatudi.
to Phatudi.
Yes.
So you are no longer a shareholder.
That's correct.
So meaning you are no longer the owner of the MJ Phatudi Incorporate.
That's correct.
You are just a director.
Yes.
Then from there, anything else owned by MJ Phatudi Incorporate doesn't belong to you. It belongs to the shareholders.
Yes.
And that shareholding has been released to Phatudi.
That's correct.
Then what happens to the directorship?
Well, the directorship, like in this case,
Yes.
because the main person, main role player,
Yes.
had ceased to practice, then it means it died its natural death.
No, the company
What-
still
what
the
is-
company is still registered with CIPRO, and for as long as it's registered with CIPRO, it must have a director.
Actually, yes, the directorship to be, it all depends, this, what we call executive director and non-director,
Yes.
executive director. So for purpose of continuity in the transaction towards the conclusion of the sale, it needed somebody to sign conveyancing papers.
Yes.
And I had no choice because.
No,
for-
Judge, I'm not interested in the house.
Yes.
I'm interested in the company
Yes,
that holds the house. I
Yes.
want to know, now that the shares are gone to Phatudi, and then the company is registered with CIPRO, whose name does it appear at CIPRO as a director?
oh, I see.
Yes, at
Okay.
that point.
At this point, Phatudi has taken over as director and I can refer you to.
So she has taken over as a director
And the
and
shares
a
as
shareholder.
Yes,
So meaning she has taken over even the liabilities and the properties and all of that of the company.
yes, Commissioner. And that, there's an annex just there on
Yes.
on this response. It's marked as MG2 sorry, it's marked there that the director is now Alice Phatudi Alice. It's written there. She's taking over the directorship
Yes.
as well as the shareholder.
So this house, the house in question now belongs to Phatudi as a shareholder and the director of a company that is housing this office,
That's
which is
correct.
in dispute.
Yes, that is correct.
So because you are a community there, this man knows you are practicing in that office.
That's right.
He comes to you and says, no, we want that office where you used to practice.
That's correct. Yes.
And out of cordiality and working relations, you say, no, the office is available. I can even take you there.
Yes.
Because you use different languages here, you call it facilitation and all of that. From what I'm listening is, a man approaches you during the opening of the office, you even take a tour at the office there, then you hand him over to the real owners of the office.
Yes,
Then
that's
when they are busy renting there, they don't want to pay.
rental.
And
yes.
when you start fighting for rental,
Yes.
they start writing letters here to complain about you.
That's correct.
Thank you.
That's correct, Commissioner. That's how I also understood it.
Follow up,
I can,
follow up, CJ.
Yeah, it looks like we have in our Julius Malema S. Who wants to follow up? We must pursue law. Who wants to follow up? Okay, please follow up, sir.
Thank you, CJ. Good afternoon, Judge.
Good afternoon, Commissioners Gogo.
The issues which I will need to be clarified.
Yes.
Yeah. About this incorporation. When we incorporate a company, a personal liability company, we do memorandum of incorporation.
Yes.
I think back then in 2000, it was articles of association.
Yes.
In the memorandum of incorporation, we state what this company is going to do.
Yes, the main business. Yeah.
The main business of
That's
the
right,
company.
yes.
And what was the main business of this company when you incorporated it?
No, it was registered as general trading or trading in general matters.
And it also ran a law firm as a general trading.
No. When I became an attorney, I traded in that building as attorney MG Phatudi Incorporated. Now, the main business upon registration of this company was registered as general trading, but I only used that property and the business name MG Phatudi Incorporated to practice as an attorney. Now, when I ceased to practice as an attorney, the building remained registered and incorporated with nobody inside.
I'm not talking about a building as yet, and I'm not sure if I'll talk about the building. I'm talking about MG Phatudi Incorporated. What is the memorandum of incorporation of MG Phatudi Incorporation?
With respect, I thought I've answered that the company was registered as a general trading company. That was what was included in its memorandum and articles of association.
Okay, so then I think maybe if the Law Society had known that that is the memorandum of incorporation or articles of association, it will not have allowed you to operate.
Unfortunately, they did because I informed them.
Okay.
Yes, there was nothing illicit about this. Absolutely not.
Yes.
And so far, even when I returned my Section 78 audit certificates, I did so attaching the letterheads and everything to show that I'm trading as MG Phatudi Incorporated.
Okay. So let's come to shares.
Yes.
In terms of the Attorneys Act, under which you operated, the people who could hold shares in an incorporated firm of lawyers,
yes,
are only lawyers and no one else.
If you're practicing as an attorney under Fidelity Fund certificate issued under Section 78.
No. Let's not deal with the Fidelity Fund certificate. Let's deal with the incorporated, because I think it will be very clear. Personal liability companies in the Companies Act are reserved for professionals, are reserved for medical practitioners, are reserved for accountants, are reserved for lawyers. And they operate under incorporation. And it is personal liability because the liability, I want to deal with this, the liability of the company are not separated from the liability of the directors.
Yes, I agree.
So,
So what's the problem, Mr. Sgogo?
so there is no two personalities like in other companies, because if that is allowed, members of public will be left in the cold, will not be protected by the legal practice fidelity fund. Back then it was the attorneys fidelity fund. If they were separated, they were one thing. That's why only lawyers in that incorporated will hold shares and will hold directorship, no one else.
In which company are you referring? Are you still talking about MG Pal Incorporated?
Yes.
Okay.
If it was running a law business, unless if it was running something else.
I would like to say MG Phatudi was trading, Incorporated was trading as attorneys up to June 2016. But between this period of April, when I went for interviews and having received a recommendation for appointment, then I started to put systems in place in order to, I would call it in inverted commas, to liquidate the business. And one of the quickest things that I thought of, because there were things like furniture inside and many other things, including the property itself. That is when I informed the Law Society that I am no longer practicing for purpose of, say, expecting a fidelity fund certificate from me anymore. And then the building, the shares and directorship was then, prior to that, transferred to Mapatu. And that was effected, according to the CIPRO documents that I have, on the 7th of April in 2016. It appears in my response.
This complicates issues. Because if the shares and the directorship were transferred on the date you just mentioned now, you signed the documents for the sale of the building in 2018.
Yes, that is correct. But in my capacity, not as a judge, but as the registered owners initially recognized by the Deeds Office in 2005. There was no any other person who could sign the transfer documents.
No, if you transfer your shareholding in a company, and when that company holds properties, the new shareholder should sign, not you.
No. That is not the position. That is not the position, Mr. Skoko. Ownership of the building, he who or she whose name is registered in the name, in whose name and building is registered, then in that case, that person must sign in order to effect the necessary transfer. Not of the shares, but of ownership of the business, of the property.
Thank you. I think you have answered, and we should stop somewhere in regard to this interaction.
Yes.
And I will raise some of the concerns during deliberations.
Okay,
thank you.
Well, just to clear this in my mind, didn't you say, in response to Honorable Malema's questions, that the shares and the house were all transferred to Phatudi, with the result that even as you were taking somebody to the house, you are not taking them to your own house, you are taking them to something that belonged to Phatudi. So how can you answer Mr. Sigogo in the manner that you are answering now?
I don't. I tried to explain earlier on, but
Okay.
looks like we're hitting a snack.
We don't get it. Yeah, we don't get it. Okay, okay. Honorable Minister.
Yeah, thank you, CJ. I hope the confusion has been cleared. As I was also a bit confused with the signing of the deeds of sale to the new owners of the property. But I think Mr. Phathudi's last answer clarified that confusion with me.
Yes.
Because I also understood that with this company of a limited liability, but I get your point that it is because you're a transferor, it was an administrative process to transfer the building. So I understand that part. I was a bit confused earlier on.
Thank you.
So my question relates to, I just want us to move from this. I think it is enough now. My question relates to the issue you have raised about the contest between Public Works and the Department of Justice.
Yes.
With regards to maintenance of the buildings. It's not only a Limpopo challenge, it's a countrywide situation. What do you suggest we should do to resolve this difficulty for the infrastructure?
Well, if the minister, if the government has enough fiscus, the immediate thing would just to overall refurbishment of the structures, because as they are, some of them, according to the research that I've done, are in a state of dilapidation, dangerously so, to the extent that it puts the lives of our people in danger. The court, for example, in Toyendo may collapse at any time because it is old. At some point, it caught fire because the electrical system was in a state of disrepair. The same applies to many other courts in the former homelands. Your Bochum areas, your neighbor, and many other courts, Linyenye, Bulubedu, and so on. These, what could be done, Honorable Minister, is that they need a total overhaul or refurbishment. And I will cite reasons why I say so. In Zanin, for example, the holding cell has a hole between the property and the main street in town, with the result that the laborers there and those who came to court easily sneak in unwanted material into the holding cells, your knives, your dacha, and related matters.
Yeah, Mr. Phatudi, those problems we know.
Yes.
And we understand. My question relates to how do we solve them? You know, when you come to us, we say, no, it's a public works issue. As you are aware, it's public works that deals with state infrastructure.
Yes.
And you have said here that there is some form of a contestation, or you're saying there's some form of shifting of goalposts between the two. And when you go to public works, they say maybe they will say justice has not yet reported or is part of justice in terms of their delegated kind of responsibility. So my question relates to how do you think we must be able to solve this problem? So that you know, if I have this problem, I go to this point. No one is going to tell me it's belong to this. That's one tell me that this problem is going to be resolved and this is the procedure. So that is the point I'm asking. How do you help us to help you resolve this challenge that I know is countrywide, because I've also seen it?
Yes. Well, my view would be this, Mr. Minister, in relation to your question that the first thing would be to transfer these courts in the names of the Department of Justice, and the department takes over and rather enters into a maintenance agreement with Public Works, which I believe it is an administrative responsibility of maintenance of all state departments' properties. So I think the quickest way would be to enter into, rather transfer these properties and be owned by justice, so that we must know, the public must know that it's either is owned by the Public Works or justice. And if the issues of maintenance arise, say in the future, then we know which department to deal with. Maintenance contract is very important, and transfer, if all possible, of these assets into ownership of justice, that would help resolve the problem. But again, it's a matter of the executive.
Yeah, the difficulty I have with that is that, as you are aware, Public Works is the state agents with regards to these issues. So we have had some kind of, they have delegated some of this. I think, I can't remember the level of maintenance, which is kept for the Department of Justice.
Yes.
But what is emerging from that is that, obviously, when they delegate, remember at Public Works, they already have a dedicated unit and officials. Those officials and dedicated unit remains with Public Works. So justice may also not have that capacity of all the officials that can help across the country. But I think it's something that we can look into and outside this platform for further exploration as to what becomes a real workable solution. But
yeah.
I think I get where you're going to.
Yeah, if I may, if I'm allowed, Chief Justice, just to make a follow-up here as part of the solution, is that, Honorable Minister, is that steps could be taken to ensure that these, in every cluster, there is a head who is put there to make sure that issues of maintenance, refurbishment, and so on will be ensured. But on the other hand, there is this problem that in the provincial administration level, or at that level, we don't have MECs of justice. So therefore, there is a chasm between the administration at national level and the provincial offices in matters of public works administration. So it's one of the things that compounds the problem, because there's no immediate overseeing role by, say, for example, the MEC of justice, who will run around the whole provinces to see the state of this of repair of these courts.
Yeah, no, thank you, CJ. I think on that one, we are looking into the role of the regional heads of justice to be given more powers to do those kind of things. But I think it's something we'll engage outside the platform. Thank you, CJ and Judge Phatudi.
Thank you, Minister. Honorable Mwema.
Thank you, Chief Justice. Good afternoon, Judge Phatudi.
Good afternoon, Commissioner.
I think from the elaborative discussion that we have had, I want to ask you two questions.
Yes.
And the first one is whether do you agree that these problems that were raised and your time trying to set out the situation as it is has a potential to create a deficit in the ability of the public that has complained to the JSC about the the independence of our courts and the judiciary, because they would have understood that the independence of the judiciary is not about judges per se, but rather the system of justice and the rule of law. And that is the, will you also agree that if that is the understanding, definitely because of failure to clearly delineate a distinction between the institution and yourself, which has been difficult to explain, there's a potential to undermine public trust and confidence in our courts. Do you agree that if the public has confidence in the independence of our courts, all of us are winners? And if there is no independence, all of us will be losers. So don't you think that it might be important for you probably to step aside, allow the process to continue so that you sort out this confusion, because it's also a concern now to the to the structures.
I see.
Thank you.
Okay. Honorable Commissioner, first and foremost, you'll appreciate that if, with respect, you have gone through the response that I've provided in relation to the objection, it all points in one direction. This is a non-judicial matter, this objection. It's non-judicial. It does not blemish in any way my independence or any possible, let me say in particular, my independence as a judge. It's a product of a transaction perhaps that went sour, that affected the a particular, I would say in this case, for lack of better words, the PSA. But for the allegations that are there, for example, I've provided countervailing evidence that would tend to show that this is nothing but personal issues which do not affect PSA as a body, but the person who happens to represent that body in the lease agreement. That's the beginning of the whole problem. But then after I had taken time to explain, indeed, it might sound as a complicated commercial transaction. But to my mind, it shouldn't be allowed to spill into issues of judiciary. If it were a complaint to say that I have done something untoward personally as a judge, then obviously from the moment when the allegation arose, perhaps bordering on unethical behavior, surely the Secretariat of the JSA would have been the first to receive a complaint. But now the complaint, look at this, Honorable Commissioner, the objection comes a second time. In 2019, I had to withdraw because of the same allegations which are repeated here. There's nothing new. I've tried to attach, not tried, I've attached, as you will see, I've referred rather to the initial complaint. I've been open to this commission, played my cards face up. And I've attached this thing. If I was somebody who is playing hide and seek, I wouldn't have produced this document. But then I wanted to show this commission that the timing of this objection is questionable, in the sense that it's a repetition of what was contained in the first, and it came at the 11th hour in circumstances where if I took a risk of coming here unprepared at that 11th hour, I don't know what could have happened to my reputation. Now, I had to back down, like it was suggested by the writer of the initial report, and even this one, that I must withdraw my candidature. And of course, I've gladly done so, because I had to find time in order to collate evidence to negative these allegations. So I would, in answer to your question, say it's unnecessary for one to think of, in the first place, of backing down again. But the best was to come and show you by way of this document, which took me days to collate. Remember, I had to go to Treasury, obtain this document, try to show the writer that I did not sign the lease myself, and related matters. And the other allegations made here, which are all negated by documentary proof that I've attached for the benefit of the commissioners. So the judiciary cannot be undermined by allegations of this nature. They're too unnecessary, really, to be honest. I don't want to use other words. It's unnecessary.
The confidence, don't you think that it
The
has
what?
the potential to
The contents.
the public confidence
Oh,
in our courts
no,
from this process?
no, it won't. As I say, it will only do so if the issues complained or raised border on judicial ethics. So these are not judicial ethics. These are personal issues. The timing of which was always like this. At the 11th hour, then, okay. Commissioner, I'm not sure whether did you have opportunity to go through other comments made by other credible law bodies.
Yes.
Six of them were all in favor of my recommendation by this commission. Of course, it's just a recommendation, I know, but then just one dissenting voice out of six. What is that? And it's a repetition.
Thank you, Justice. Thank you, Chief Justice.
Thank you, Honorable Moimang. Commissioner Tsepe.
Thank you, Chief Justice. Good evening, Judge.
Good evening, Commissioner.
Judge, I want to step out of the discussion on the property. There's one clarification I need though, but we'll get to that. Yes. When you were talking earlier about the challenges facing the division, I think it was after the CJ's questions, you spoke mainly about infrastructural challenges. Yes. I want us to talk about challenges, or if they are, relating to the running of the court, of the division itself. And I wanted to find out from you if there are any challenges that face your division that might hinder timeous delivery of judgments. And if there are, what interventions would you propose to capacitate the judges to meet the expectation in this regard? Yeah.
All right. Let me approach your question from this perspective. First, that court in Limpopo, both the Polokwane High Court and the Thohoyandou local division of the High Court are, to my mind, running quite efficiently. But the challenge is this. In Polokwane, for example, we have a great deal shortage of judges, permanent judges. This has been the position since 2016, when the court was established. I know the JP has been engaging with the various ministers in the Department of Justice to try to strengthen the division by introducing more and more judges. But it looks like, as I understand, that the money is gone. there's the fiscal has been depleted, the fiscus. And we're not being promised as to when sooner will more judges made available. Now that put a spanner on case flow management, as well as the judges being overworked, because you're required to sit almost every day in court. At times when you're assigned to do motion courts and then it collapses, then you take over criminal cases. There's no what you call reading days in Polokwane. Now, we work every day and twice on Sunday. At times we're unable to go to church because spending 2-3 hours in church, when you come back, the day is gone. It's Monday already, and that affects the production of quality judgments as speedily as it is required of judges to produce judgments. Now, these things impact negatively on case flow management. The other issue is the dysfunctionality of the recording machines in our courts. I'll speak on behalf not only of the High Court, but I heard even in some district magistrates court there are problems there. Most of the time, those machines are not working, and there are no backup systems, with the result that in the middle of proceedings, in the afternoon, then the whole system collapses. And that makes our work difficult. What are the solutions? The solutions, again, is a question of maintenance agreement between the department and Public Works. That's my submission.
Thank you. Judge, I just wanted to check something in relation to the memo. I think that you wrote in response to the PSA's
Yes.
Objection. I want to categorize it as that because it's not a complaint to the JSC in the normal course. This is just an objection to your application.
Yes.
I wanted to understand why, somewhere you say that he wrote again to me, meaning he wrote a letter to you in one of the, in the memo. I wanted to understand that if Phatudi,
which paragraph would that
I'm
be?
trying to get the, 13. Pursuant to the above stated notice,
Which paragraph?
13, paragraph 13.
Oh, okay.
I think it's page 4 of paginated page 4. Mukari SC again wrote to me
Yes.
on 14 June 2018.
Yes.
So my question is why you were facilitating the process of viewing the lease property with Mr. Mukari at the time of entering into the lease agreement. I understood you to be saying that's the end of your participation in this transaction because the transaction would have been between PSA and MG Phatudi Incorporated, represented by its director and shareholder, Phatudi. So why would Mr. Mukari then write to you in 2018 regarding disputes relating to the lease agreement
I see.
when you are no longer? And as you say, he wrote to you again, meaning at some point prior to 2018, he would have written another letter to you regarding the continuation of or termination of the lease.
Okay.
And it, this raises a concern for me that you were still participating in one way or the other in this. So if you could clarify that for me. I heard the minister saying your answer about you signing the transfer clarified it for him. I just want to say I didn't get the clarity, and if you could, I know you've traversed this matter a number of times, but I just want to, I don't want to go into the deliberations with question marks in my mind. And if there is clarity that I get from you, I would much rather I get that directly from you. You said that the, the property is in the name of MG Phatudi. When in 2016, when you left, you would have resigned as a director, and Phatudi would have been the sole director, because the certificate shows Phatudi as the only director, the only active director. So it shows that you're no longer the director in terms of the annexure on here. What I wanted to find out is once you have sold the shares, so the shareholder and the director would be Phatudi. So the shareholder, the director would in-law, or the board, which is represented by the director, are the only people who can represent the entity. So that would be Phatudi, because the property is in the name of the Inc. So how would you then, having transferred the shares and the shareholding of the Inc. to Phatudi, still have the authority to sign transferring papers? Because that act can only be done by the person who is responsible for the company. And that person would be Phatudi, not you. That's my understanding of how companies are run.
I see. Okay, let me start with you, Commissioner Sepe. Let me start first with the letters that you've referred to. It was an interval of just 2 days in between. The one was issued on the 14th of June 2018, in which the author refers to paragraph 1 thereof, as per our telephonic discussion previously. So there has been an ongoing discussion in terms of which the society had conveyed their predicament in terms of continuing to pay the lease. Now, if you turn to page 3, that's the reason why that letter was written, that the situation is beyond our control, and we therefore cancel the agreement as stated above. I was informed. Now, you want to know why was the letter directed to me? Go back to say that we had a good working relationship with Advocate Mokare, so he knew me, but I facilitated the transaction. That does not derogate from the fact that initially when the lease was signed, I facilitated the lease agreement. Similarly, the page before is a letter dated 16 May 2018. Paragraph 2 thereof says the Bar Council of Polokwane Society has resolved not to exercise its option to purchase the property at any stage. You are therefore advised to proceed to sell the property to any willing buyer. So he gave an advice in writing so that I conveyed to the person who's in charge of that property.
Chief Justice, I think that's fine. I just think my challenge still remains, Judge, in that if the person responsible for the property is Phatudi, whose details would have been available to the PSA, they would have written directly to Phatudi, or you would have responded to the PSA and said, sorry, you are addressing your letter to the wrong person. The person responsible for this matter is Phatudi. in future, in order to not create any
Yes.
difficulties, could you please direct all your correspondence to her?
Yeah, okay. Do you still anticipate a reply? Okay, thank you.
Commissioner Matelo Lepu.
Thank you, Chief Justice. Judge, I've already treated you. You know, one of the things that worried me when you spoke about the magistrates, that they need training in, you know, and I'm a bit concerned in the sense that it seems the problems are insurmountable.
The province, huh?
The problems are insurmountable.
Oh.
In the sense that there's infrastructure, and here there's human capital of magistrates not being trained. So for me, I see this gloomy picture about the courts, the magistracy, and in Limpopo. How are we going to get out of that conundrum?
Yes. There is, for now, a program meant to train regional court magistrates. But then a similar program for training is not being accorded to either acting magistrates or newly appointed magistrates. What are the consequences? The report I have here after done my research was that it results in backlog because the learned magistrates who've just recently been appointed are lacking in experience. And for example, in producing speedily judgments, and therefore that puts, it tends to paralyze the whole system. The solution is that one that, yes, perhaps one has to weave a plan in terms of which these magistrates, newly appointed and the acting ones, could be exposed from time to time to seminars, training, and any other way, method, or manner in which they could be empowered.
Well, Judge Phatudi, for what it is worth, President Maya and I serve in the Council of Sajay. We train anything between 200 and 300 newly appointed magistrates almost every year.
Yes.
And they participate in the planning and development of their own training programs. So there is a system in place. You may not be aware.
Oh yes. Perhaps I meant for the system for the acting magistrates, not regional magistrates.
Just a follow-up. I'm just worried about the women issue. About out of the regional magistrates now, how many are women who are actually senior, who can actually be asked to act? Because I don't think everybody's acting.
To act at magistrates level.
Yeah.
No, there are quite a number that I know of, and who have amassed massive experience running the regional courts, the majority in Limpopo. Having graduated from the ranks of prosecutors, additional magistrates, and others, of course, becoming chief magistrates and regional court magistrates. So the senior ones, of course, if the resources are available, they can still conduct their own training.
Okay, thank you, CJ, and thank you, Judge.
Thank you, Commissioner Matelo Lepu. Advocate Mbofu, SC.
Thank you, CJ. Okay, I thought of foregoing my slot because I was covered in my original question, but there's just something I want to clarify. I'm sorry. Good evening, Judge Phatudi.
Good evening,
Yes.
Commissioner.
Thank you very much. Yeah, no, I'm sorry, I'll go back to this issue that I didn't want to go back to, but from a different angle.
Yes.
So the minister and I are both former attorneys, so we were schooling each other here. At least we, in this thing of the intersection between the Companies and the Attorneys Act and property law and so on, which is quite complicated. So, and I wanted to apologize again to Commissioner Matonsel. We were whispering aloud, and I know it can be irritating when behind you don't know what's happening. But at least it contributed in clarifying the minister. So that's my mitigation.
Unfortunately, it didn't. It compounded the problem.
Okay. 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 Yeah. I'm sorry. So the issue really that I want to talk about is this. You are here for a leadership position as Deputy Judge President of the province.
That is
right?
correct. Yes.
And Commissioner Tsepe, I think, also touched on this. There is no complaint before this commission about you as a judge.
Yes.
Correct?
That is correct.
In other words, there's no complaint that says because of this or whatever property thing, your position as a judge should be questioned, or any of the three contestants that are here.
Yes.
And you are here to apply for a position as to whether you should be the Deputy Judge President while you are already a judge. All three of you are judges there.
Yes.
There's no question about that. Yeah. So when we consider this whole thing, it must be in relation to the simple question of whether you should be the DJP or it should be the one or it should be the other one.
Yes.
Okay. Yeah. So I think that that's very important for perspective, because I think there seems to be, don't want to call it confusion. That was the sense I was getting, that this was now about a complaint, but I think Commissioner Tsepe clarified that.
Yes.
So now let's come then to the core issue that brings you here, which is the DJB position.
Yes.
You, having acted as DJP in the position that you've applied for, can you just share with us? Someone else asked you earlier what were the challenges and so on, but what I really want to know is having acted in the position, and I'm not sure if the other two people did. Do you know if they also acted?
No, to my knowledge, not.
They did. Okay. So
it's only not between the two other contestants.
Yes.
Yeah.
Okay. So then, what advantages do you have having acted there, of having observed what happens in that division? Can you bring, if you are appointed, can you bring to the fore? In other words, what slight advantage would you have emanating specifically from the fact that you have acted there and you know what it is that you are applying for?
Thank you, Commissioner Mpofu. Yes, firstly, let me confirm that I've had privilege to act there as a Deputy Judge President for 2 terms in succession. And one of my roles was to deputize the Judge President on some of the administrative matters and quasi-judicial as well as judicial in character. And talking about the court operation itself, in that division, when you're in a DJP or acting as the case may be, on every Monday, you attend to a roll call of civil court actions or matters, which by and large would be between 70 and 80 per day on that particular Monday, most of which would be RAF matters. Of course, here and there, they would have about 5, which are non-RAF matters. Then in the process of dealing with these that is dealing expeditiously with case flow management, one would start first with matters which have been, for example, if it's an RAF matter, settled. Then you know that if you go draft order, then you quickly dispose of those matters. There are instances where there would be removals of matters from the roll for a variety of reasons. And one of them might be that the matters are not trial ready. And what do? The other issues will find that there are no property discovered, matters are not properly discovered. In other words, there are no discovery affidavits, especially for the plaintiff. Such a matter cannot proceed to trial. And that is one thing. And the matters which, fortunately, under the amended Rule 37 of the Uniform Rules of Court, one is able to immediately engage on a process of mediation. And for parties who came at each other's throats, at 11:30, after you've made some few interventions, then you are provided with a settlement or a draft order settling the matter in its entirety. So those are some of the tactical skills that I've employed whilst I was acting. And not only that, even now as a judge, after having been not relieved, because that may give a different impression, after my term has come to an end, then the JP is, because for the purpose of that call, I'm one of the senior judges. I know some people might think that one is senior in terms of protocol.
Yeah.
Then I've continued even now from January, when we reopened to date in the second term, that I'm still in charge of the role. But the matter does not end there. I have represented the JP in the Judicial Case Flow Management Committee, consisting of various heads of court in the country. Previously, it was headed by the late DP Mtiani.
Yes. Judge, I don't want to interrupt you. If you just give me the highlights because of
Yes.
time, I'm just
Yeah, okay.
sensitive to that. But
Okay.
I've got the 2 or 3 issues you mentioned now.
Oh, all right. No, the other thing is I'm one of the members of the Performance and Monitoring Committee, a committee responsible for the overall performance of the courts, both in Polokwane and Thohoyandou. So that requires a great deal of experience in terms of how you encourage your colleagues to deal with backlog, both criminal as well as civil matters. And with regard to enhance case flow management, I have actually proposed to the JP, for example, in the past, that some of the portions of the practice directive, in order to alleviate backlog, had to be considered. Example, matters which fell within the magistrates stroke regional court monetary jurisdiction were all discouraged from being enrolled in the High Court. Initially, because they made our court to swell up to 80 or so unopposed motions. Then what we have done, we have proposed that those matters should be transferred to the magistrates court where they belong, because they're justiciable there, without really dismissing or striking them off the roll. Now, over the years, the practitioners have complied. They no longer issue a process with money below that is really justiciable in those courts. Again, and I must say that after having done so, the JP initially issued a directive, and guess what happened, Commissioner? That directive later received the attention of the full court in Pretoria, who followed our example, and they produced a judgment that such matters should be, rather not be entertained in the High Court. And all cancellations, for examples of motor vehicles of people who were defaulted in paying, were all referred to open court. And after having realized that people have turned this court into a debt collection agency, then we have set the registrar in terms of Rule 35, Sub-Rule 5B of the Uniform Rules of Court, could summarily deal with those matters without referring them to court. And the court became. Those are some of the proposals I've made, and I will continue to make.
No, thank you very much. You've covered my next question, which was going to be, because there was a candidate earlier who wanted to be a DJP and he didn't know what the role of a DJP is. But I think that some of the examples that you've given cover my next question. Thank you. Thank you, Chair. Thank you, CJ.
Thank you so much, Commissioner. Prof.
Thank you, CJ, but I'm covered, thank you.
Thank you. Honorable Malema.
Thank you, CJ, I'm covered.
Thank you. Advocate Kennedy.
Thank you, Chief Justice. Good evening, Judge, again. There is a matter that has been drawn to my attention. It pertains to a judgment which you delivered on the 1st of April 2021, so very recently. If I could try and trigger your memory, and you can let me know if you need more detail or whether you can recall the matter. It pertained to a firm of attorneys practicing in your division against whom a winding up order was granted. And you gave urgent relief, preventing the winding up proceedings from progressing and halting a Section 417 inquiry. Can you recall the matter? May I ask you some questions about it?
Yes, I do recall that matter.
Thank you. I was given a copy of the transcript yesterday, and I'm sorry that this couldn't have been delivered to you before I ask you questions, but maybe you'll recall. What appears to me is that on the 31st of March, you heard argument on the question of urgency, and then you stood the matter down in order to come to a decision on the issue of urgency. And you informed, and it's on the record, you informed those in court that you would only be dealing with the issue of urgency overnight, and that you would give a ruling on that issue the following day.
Yes.
And that all that was required was for legal representatives to be present the following day to note the judgment. And that was in fact clarified with you. The specific question was asked that whether the legal representatives need appear, and you said, no, you don't have to, you can send correspondent attorneys to note the judgment.
Yes.
Now, on the following day, you handed down a judgment in which you found on the issue of urgency, but what you also did is you went on to give substantive relief on the merits. You gave interim relief in favor of the applicant. The relief was for a period of 7.5 months because you said that the applicant could come back to court in mid-November, if I recall correctly, to address whether that relief became final. But then you also gave final cost orders in the matter. And those final cost orders were also against the commissioner in the Section 417 inquiry, who had not opposed the relief. He had said he abided by your order, and nobody in court or on the papers had requested that costs be granted against him. I would like you to just address us, please, on that issue, that why it is you gave interim relief, not having heard argument on that issue, why it is you did so in the absence of the legal representatives, and why you gave final costs orders when you hadn't heard argument on that.
All right, firstly, Commissioner, it's a pity I haven't been provided with the transcript for me to peruse. And to
Yes, I did
verify.
acknowledge that and
Yes, but
apologize
then
for it.
let's-
I only
I'll
received it
endeavor-
yesterday. You can,
I'll endeavor to answer your question.
yes.
The matter before me found its way in my court by way of agency. And from the word go, I've asked counsel in the nature of the things as they were, and given the agency of the matter. Because the commissioner concerned, appointed under the Insolvency Act, provided or rather delivered a notice to abide the court decision. In other words, did not participate in the proceedings pertaining to agency. But to my surprise, on the very same day as I was sitting in the agent court, the Honorable Commissioner, a judge for that matter, despite the fact that he filed a notice to abide, proceeded with the inquiry, the insolvency inquiry against the applicant. And that to me left me with the impression that first the matter is urgent because now the relief he seeks is that he as a commissioner should not be proceeding with the inquiry pending the outcome of the main application. So the matter before me was not dealt with on the merits, but only issue of agency was considered. And which is why I issued a rule NISI. But with respect, Commissioner, I do not appoint dates, especially in opposed motions. Dates are being provided for by the register. Now, the date of 7.5 months, as you've mentioned, it was not out of my own making, but that is what I've been provided for, that the rule NISI will be is returnable somewhere in November. I can't remember the date for now. Now, turning to the issue of costs, indeed, the notice of motion was such that the costs be paid.
Judge, with respect, could I draw your attention to the part of my question? You had not heard the parties on the merits. You had excused the legal representatives from court, and you had stated you were only going to rule on the issue of urgency.
Yeah, let me respond to that one. And I think I repeat for the sake of emphasis. I have asked counsel on the day of the hearing of the matter that we shall not be digressing into the merits, but we're only going to focus on agency because the nature of the reliefs sought was such that it could not wait, because by the time merits are considered, the whole thing shall become superfluous. Now, for that reason, I have decided, and with the consent of counsel, that let's not focus our energies on the merits, because the merits will also be dependent on the outcome of the inquiry that is taking place there, which the applicant sought to restrain in those insolvency proceedings. And given the facts asserted in the affidavit, explicitly setting out the agency, I became satisfied that the matter was sufficiently urgent, and therefore I granted interim relief. The position would be somewhat different if I granted final relief. Then that will be a matter for concern for me.
Judge, I'm not permitted any more questions. We're under strict time restraints. But I will in fairness say too that the issue of granting interim relief is what I'm referring to as the merits. That was the merits of the application before you. You agreed that you had not heard the parties though on the issue of whether to grant interim relief. When we say the merits, we're talking about interim relief. Are we ad idem in that regard?
Commissioner, the nature of the relief granted was not finally dispositive of the issues, which otherwise fell within the parameters of the merits. So therefore, I do not really understand what your concern is, because that issue, which is why it was granted as an interim measure, it did not lead to final dispositiveness of the matter. So if the merits are still going to be heard in November, so there's no prejudice. The door is not shut.
In other words, if I understand your answer correctly, you are entitled as sitting as a judge, or you would consider it proper to give interim relief without hearing the parties on the question of whether you should give interim relief.
The council were present, both for the first and other respondents were there, except Judge Battersman, who was a commissioner at the time. Now, the point I'm making is this: council were heard not on the merits, but purely on agency. They were present in court. It was not in their absence. And we agreed to not digress into the merits, because as matters stand, this matter was such that it could not have awaited until the next available opposed motion date, or post-motion date. It would have become academic for the applicant to give him cold comfort, even if he wins thereafter, because the role of the commissioner, as we're busy hearing these matters on an agent basis, he was busy there with a private inquiry. But in the same breath, having delivered a notice to abide. You see, that's what really made me flabbergasted.
And is that the reason why you granted a costs order against Bertelsmann without hearing him at all on that issue?
Well,
final costs order.
Well, I can't remember whether I could have granted final cost order against, when I say the matter was just on interim basis. It's a pity I don't have copy of that.
Could I read your order to you? May I read your order? The last part of your order is that the first to fifth respondents.
This is probably the fifth or so question. Do you want to tie it up? I can see you feel strongly.
Thank you, Chief Justice.
Maybe just the last question,
yes.
Really. Yeah.
All right. Thank you, Chief Justice. Thank you for the indulgence thus far. Judge, you granted a final cost order against 5 respondents jointly and severally. Included in them was the judge to whom you've referred. Will you agree that you did not hear them on that issue?
Initially, all the respondents had opposed, filed notice to oppose. It's only on the day of the hearing of the agent application that notice to abide. So plaintiff was put, rather, applicant was put at, how can I put it, in a position where he had to engage counsel, attorneys to brief counsel, and counsel ultimately to come to Polokwane from Pretoria or Johannesburg. So those were expenses. If a person wants to abide, you do so in advance because you've been served with the papers. You don't just drop
Judge, I will leave the issue there in the interest of time and because the Chief Justice has asked me to wrap it up. Thank you. Thank you, Chief Justice.
Thank you, Commissioner Kane. Commissioner Barner?
Thank you, Chief Justice. Good evening, Judge Phatudi.
Good evening.
I just want to confirm with you, the MG Phatudi Incorporated had a trust account as a law practice. Is that correct?
It had, yes.
And on what date was that trust account closed? The banking account now?
It was closed shortly before the end of June 2016.
Because it seems to me that the MME Phatudi, or your spouse, I think, became a director on the 7th of April 2016.
Yes.
If I look at the document you provided.
That's correct.
So the trust account was still continued by the incorporated after there was a non-attorney or non-legal practitioner as a director of the firm.
By that time, Commissioner Barnett, having received the news, I'm not sure whether was it on the 4th or 6th of April in 2016, news from the JSC that you've been recommended for appointment. Then I immediately knew that I had to begin with a system of liquidation, so that by the time the 1st of July comes, the trust account is 000. Now, from that moment of the 6th of April, the practice was not receiving money anymore in the trust account, which is why it left a zero balance end of June. There's a letter to Law Society to that effect. It's just that in the interest of time, but I think I have a copy somewhere.
Thank you, Judge. Thank you, Chief Justice.
Thank you very much, Commissioner Barnett. JP Mlambo.
Thank you, Chief Justice. Robert.
Yes, Commissioner. Okay. Commissioner, thank you very much.
Are you okay?
Yes, I'm all right.
Good.
Yes.
Just to follow up on the question by Commissioner Kane. To me, the question is simple. You agreed with her that you stood down the matter to determine the issue of agency.
That's to make, yes.
Now, usually in
To
an
make
agent
a,
application.
sorry, to make a ruling the following, because it was very late.
Yes, but on the issue of agency.
That's correct, yes.
Yeah. So usually the order sought in agent application is the first order sought is an order that the matter is urgent.
Yes, that's correct.
And then other orders follow.
Yes.
So I think the number of the questions that you were expected to make a ruling on the first prayer sought agency.
Not only that, because there were other things in the prayers in the notice of motion.
Okay, no, I was just explaining to you that that was her question to say,
okay,
when you stood down the matter, you knew what orders were sought, but you said we won't go into any of the other things. Let's check first whether
the matter is
I
urgent.
agree if the matter is urgent.
Yes.
You agree with that?
That's correct.
And the question was, the next day, you not only issued an agency order, you went further and issued other orders, including cost orders. And the question was, why did you do that?
All right. No, it's because JPD, the answering affidavits were already there. The parties came to argue agency, and that is why at the end we had to say, all right, now the costs have been granted, and the rule is also granted, and the costs are granted because they were opposing even the agency itself.
Okay, no problem. I won't belabor the matter. I'm putting these questions in fairness to you because I put them to Judge Modao.
Oh, I see, okay.
The first one is, do you subscribe to the view that you applying for a leadership position, so as a leader in the judiciary, you've got to be proficient as a manager, administrator, as well as a jurist of note?
I agree.
Do you have any judgments that you can, out of memory, that you have written that have gone to the SCA, been upheld, or even gone to the Constitutional Court?
Yes, I do have may you allow me an opportunity to?
Now, if you've cited them in the application,
Yeah, they are
JSC,
there
so
in
we'll
the,
find them.
they are there in the questionnaire, Chief.
Because
I
I
mean,
couldn't see the
GP.
indication to whether those judgments went to the SCA or went to the Constitutional Court.
Yeah.
But if you say they are
there
there, I take your word.
Yes, JP. There are those which I've marked that they were upheld, and then those which someone tried to appeal and were dismissed. I think I've listed them there in the questionnaire.
Okay, no, I take your word for it.
Thank you.
It's late in the day after all. The last question, that was a follow-up, CJ, I'm sorry. The last question is, you've mentioned that you've represented the JP in, I think you said case flow management meeting. I think you're
Judicial.
referring to the PEC, are you not?
It's JCFM.
The JCFMC?
Yes.
Okay. But do you agree with me that the biggest problem in our judicial system are the unending matters, the backlogs in terms of trials that never end, especially those in the regional court?
Yes, I am aware.
Now, as a judicial leader with the responsibility in terms of Section 8 of the Superior Courts Act, what do you think we can do to address that problem? Because it's a big problem. Some trials last longer than 5 years, sometimes 8 years.
Yes. Some of the very same concerns you raised, JP, are contained in this report, which I have sourced from the regional office, dating back, it says it's 2019. Now, in terms of Section 8 of the Superior Courts Act, indeed, as a deputy to head of court in the province, the first would be to make sure what are the causes of these backlogs. I've already intimated earlier on that incessant power cuts, electricity, shortage of water, intolerable working conditions in the courtrooms and so on, overworked legal aid officers and related matters, all impact negatively on the speedy finalization of cases and hence the backlogs. Now, what do you do to address that problem is from time to time for one to visit the areas, see the state of repair of those infrastructures, and at the end of the day, come up with solutions. And what will be the solutions is what the minister earlier on raised. I said, having a formal contract between the Department of Public Works and Justice.
I think I was asking you as a leader what you could do. I think you've answered the question.
Yes.
What you would do as a leader.
That's what I would do, yeah.
Yes. And Chief Justice, I'm done, but just to clarify to the candidate that the magistrates' court matters in the high courts, that matter in Gauteng, it's the Tobejane versus Nedbank matter.
Yes.
It was not arising out of a directive issued in Limpopo. It was a directive issued in Gauteng. And the country still waits direction from the SCA in that matter. Thank you, CJ.
Oh, I wasn't always appealed against.
Honorable Klaba.
CJ, I had forgone my slot after you had granted me permission to ask a follow-up question. Thank you so much, CJ.
Thank you, sir. Commissioner Sigogo.
Thank you, CJ. Judge.
Yes.
The Limpopo High Court has two local divisions. Currently, it is only one local division which is operating, which is Toyando.
Yes.
Which is just less than 200 kilometers away from the main seat, which is in Polokwane. If in your thinking, what do you think? Should the JP and the DJP sit in the same court, or should they be in different courts? And why?
Well, given the capacity of the court in Toyando, as you might be, as you know, it has only 3 courtrooms with 3 chambers, and it's a very small establishment which was created in terms of the old law of establishing Venda as a republic. So for now, even if a DJP were to sit in Toyando, there would be no space. Those judges who are sitting there have their seats permanently established and they're anchored there in Toyando. To rotate them, for example, to say the DJP should shuttle between Polokwane and that, ideally it would be a good proposition. But practically, in terms of financial constraints, that is a bit of a problem. And that is a matter that even the JP himself will not be able to deal with. It requires a lot of finance. And as you know, nowadays money is a scarce commodity. So that's number one. Secondly, because of the shortages of the judges in Polokwane already, to remove a DJP to go and sit in Toyando, you will be creating yet another loophole. Given the fact that there is a lot of work, the work volume there it's so high that if you detach one of the judges to go and sit any other place, for example, even Lepalale, where I know it does not yet being operational, but the day say you need a week or 2 of judges sitting there, then the system becomes compromised.
Thank you. That we will take it outside this forum and we will engage. But this question I asked the previous candidate. I'll also want you to answer. Limpopo has 1 female judge.
Yes.
As we speak, and has a male DJP, a male JP. And this position which we are interviewing for is replacing a female judge. I would like you to share with this commission as to how and one of the candidates is a female.
Yes.
And how your appointment to the position will enhance transformation of that court.
Okay. Now, the answer is this. Firstly, the appointment of judicial officers is regulated by the provisions of Section 174, subsection 1 of the Constitution, and also subsection 2 thereof. Let me approach the question as follows. First, I'm in favor of females, judges being appointed to the judiciary. That's very clear, no compromise about it. But any other female who's coming in, not necessarily being a replacement of the one who exited, I would appeal to that question to say, there is a constitutional guideline which is provided for in Section 174, subsection 1, which says every male or female who is suitably qualified may be considered for appointment as a judicial officer. Any other candidate who happens to be a female who's aspiring to the same position, not only in this division, but any other division, or even in higher courts, positions of management, then the provisions of Section 1742 kicks in the sense that there is then element of racial balance as well as gender. The two cannot be read separately. But the matter does not end there. You have to read 174 together with section 9, subsection 2 of the Constitution, which guarantees equality, equal treatment by the law, as well as equal protection by the law and equal protection of the benefits associated therewith. Now, if one were to say, because a female has exited a particular position, would it have an indication whether or not to enhance gender or to enhance transformation? Let me put it that way. I would say that both male and female should be treated equally, be it whether, especially when they belong to a particular previously disadvantaged group. I think that was the purpose of the lawmaker there. But not only that, you do not take any other female merely because it happens to be a female and put such a female in a position of management, unless that female is suitably qualified, equipped, and has amassed sufficient experience in court management. Now, let me give an example. If we still have time then, the Chief Justice. The position is, assuming a particular candidate has been a prosecutor in a district court, or somebody has been an attorney in private practice, whose sole responsibility was to manage that environment. And then you have someone who happens to be a magistrate, but a chief magistrate, who has under her a cluster of people whom he or she manages. Let me say she in this case. And then she wants to aspire to become a judge president, deputy judge president. Then that's where there must be a balance, not only of the race, the gender, but suitability. It's no longer a question of entry point, because that has already been achieved under section 174, subsection 1. But then 2 has its own dynamics. The needs of the court to be managed by someone who comes with demonstrated experience in management of the court systems. And that would, of course, at the end of the day, tip the scales in favor of such a prospective incumbent.
Chief Justice, may I do a follow-up?
Yes, please.
Thank you. You indicated that you are going to be 5 years on the bench July this year.
Yes.
And when I check, the female candidate who is as well contesting for this position was appointed to that court hardly less than a year after you were appointed. So, which means you are not appointed more than a year before her. So, to me, if we're to talk about high court experience, you are not far away from each other. And the other issue which I would want to engage with you is the example that you gave, that you, and I believe you as a man, a black man, and her as a black woman, you are in the same position in terms of
racial balance.
Racial balance.
Yes.
And I thought, in terms of the Triple B Act, black women are the first to be considered, or are the ones considered the most affected by the past atrocities, and then black men are not in the same level as black women. What is your comment to the two issues?
Yes, one should carefully distinguish between the requirements laid down under the Procurement Preferential Framework Act, which tends to deal when you consider issues of BEE status in either procurement or other tendering system. That would be a primary consideration in terms, if there is contestation between a particular bidder, for example, led by a black female and a black man. Let's say their own functionality on pricing and capacity, the scales are tipped equally. Then that's where, strictly speaking, in terms of the Procurement Act or measures framework, then that question would arise. But the judiciary is something else. There's no question of business here. We're talking about capacity to demonstrate experience and knowledge. And you want to say there's a difference of 1 year apart. But we don't look only at that. We look also at what has a person been doing before appointment as a judge. Because you'll agree with me, Commissioner Gogo, that life does not begin when one becomes a judge. There are other things that one has done before. Managing institutions on behalf of government, the road agency in Limpopo, for example. I became the first executive chairman, non-executive chairman. I'm just giving you an example. And many other parastatals that I've led in leadership position. Then I brought that into judiciary. And again, in contradistinction to what I've said in terms of section 1741 and read to subsection 2 thereof, where a person, for example, has not had occasion to be exposed to act and serve in management of the judiciary. And I'm not casting any aspersions here, but I'm purely trying to address my question. He who has acted, or the person who has acted, will have an advantage because we're talking about service delivery to the people. You see?
Well, maybe while you are there, Judge, as you are still answering and rounding up, you are 7 months apart as judges, and she has acted as the head of a magistrate's court. She may not have been afforded the opportunity to act as deputy judge president, but she served as the head of court. Maybe you want to include that in your answer, briefly.
Yes,
briefly.
Thank you, Chief Justice.
Judge President, just on a point of order, can we just set the principle here? On this specific issue.
What point of order now?
Just a principle here that, I mean on an issue of principle.
No, there is no problem, ma'am. Let the judge answer. I didn't want to put a question subsequently to him. The judge is well able to defend himself. Judge, please, I'm sorry to have interrupted you. I was including the issue of head of court so that I don't come later about it because you're dealing with the same question.
May I proceed?
Yes, please.
That is understood, Chief Justice. But then being an head of court in a magistrate district, one operates within a limited space in that district. But if someone were, say, a chief magistrate, for example, would under that chieftain, under that position as a chief magistrate, then you have got cluster magistrates accountable to yourself, and that would really translate the holder of that office into someone who has amassed experience. But if you only being a head of a particular district, then I do not think, in my view, that that can be compared to a person who heads the whole province as a judge president or deputy. There's a great deal of distinction there. Because I remember that under Section 8, if I may add, of the Superior Courts Act, the head of court, usually the judge president, also takes responsibility over all magistracy established in his area of jurisdiction. That's my submission.
Thank you.
Mr. Gogo.
Commissioner Sigogo, are you done?
Yes, thank you, Chief Justice. Thank you, Judge. I should attest to your love for legal education. I know I attended one of the courses that you have offered. Thank you.
Thank you.
Thank you very much, Judge Phatudi. You are excused.
Thank you.
We're sorry to keep you waiting for this long.
No. It's all in the game. I know. Actually, I expected to leave here 10 p.m.
Thank you, sir.
Justice.
Thank you.